Welcome to our panel on judicial elections, financing, recusal, and judicial independence. And welcome to the state court system, from which 95% of our common law comes, and to the process of judicial elections. We are unique in the world in that we elect a great number of our judges, about 39 states. Most of our judges are elected, and they pose and they face increasing challenges in terms of campaigning for election and financial and raising the funds for campaigns. And the issues come to the Supreme Court recently. We're going to get an overview on the issues. We've got a wide range of subjects that we're going to touch on and perhaps delve into, but we're focused on preserving impartiality, the independence of the judiciary, and some considerations as to the question of why we have election of judges at all and what impact elections have on such issues as diversity and on on impartiality and the independence of the judiciary. I'm going to introduce our panel at the outset, and we're going to hear from each of them sequentially, and then we'll ask a few questions, and the last half hour we'll have questions from the audience, as in prior panels. First, I should introduce myself. My name is Victor Kovner. I'm a member of the board of the American Constitution Society. I practice law with Davis Wright Tremaine in New York. I'm here in part because I chair something called the Fund for Modern Courts, which is a statewide court reform organization devoted to issues of independence of the judiciary, selection, and finding more resources for our state judiciary, an urgent issue in New York and many states. I also served as the chair of our state Judicial Conduct Commission and served on that commission for many years. We have a really outstanding panel. Indeed, it's a great bench that one may appear before. But let me begin by introducing the one non-member of the judiciary, or former member of the judiciary, and that's Bert Brandenburg. Many of you know him. He's the executive director of Justice at Stake, which is a national partnership to keep courts fair, impartial, and independent. It led an effort to file a seminal amicus brief in the Caperton case, which we'll talk about, just decided by the Supreme Court a few weeks ago. During Janet Reno's leadership of the Justice Department, he was the department's director of public affairs. He served on Capitol Hill and in other agencies of government, and now is a member of the National Institute on Money in State Politics. To his right is former Judge Rebecca Love Corliss, who introduces herself as Becky, who has served for 2 decades in the judiciary of Colorado, having as both as a trial court judge and as appellate judge. She concluded her service in 2006, and since then has helped establish the Nonpartisan Institute for Advancement of the American Legal System, which produces many central publications. I commend to you particularly the Transparent Courthouse, which is a summary and a document to encourage the use of judicial performance evaluation systems, which are effective assets to a number of states which are doing them. We're very pleased to have with us from the state of Alabama former Judge Harold C. Judge C. was an elected judge. He was elected as associate judge of the Alabama Supreme Court, where he served from 1996 until earlier this year. He is a contributing editor of the Federal Circuit Bar Journal, a member of the American Law Institute, a member of the Federalist Society, and we most appreciate your coming to join us here at ACS. He was in private practice with the national firm of Sidley and Austin and has served on the faculty of the University of Alabama Law School. We have to my immediate left Judge John Tiger, who was appointed in California to the Alameda County Superior Court in 2001. For the last 4 years, he served as a civil trial judge. He previously served as a partner with the renowned firm of Kecker and Van Ness. He's been also a public defender. He clerked for Judge Robert Vance on the 11th Circuit, and he is an advisor to the ALI Restatement of Torts, focusing on economic harm. And lastly, we have Judge James A. Wynn, who is an elected senior associate judge of the North Carolina Court of Appeals. He has served for 18 years as an appellate judge, and he is the immediate past chair of the Judicial Division of the ABA and is on the Standing Committee on Judicial Independence. And he's also a board member of Justice at Stake. And among his many accomplishments, I should also note that he is a captain in the United States Navy and as a military trial judge. So I thought to lay the groundwork for the issues before us, I'm going to start with Bert Brandenburg, and then we'll hear from our bench. Bert.
Thank you very much. Is this working okay? It's good to be here. I'll start by saying it's 3 o'clock, and I'm not sure why you're here. This has been another terrific and densely packed conference, and being conscious of the fact that we're in the last slot here, and also being conscious of the fact that I don't have an honorable before my title and have to earn some amount of attention here, I will say I brought TV clips. So we will be showing those in a minute. You will get a break, I promise you. And my assignment, as Mr. Kovner was saying, is to give a little bit of the lay of the land, how we got here to the current situation we're in. If you followed the Caperton case, which came down last week, it sounded very extreme. A particular justice was the beneficiary of $3 million plus support from one party. He was the tie-breaking vote to help overturn a $50 million verdict. He's asked to recuse. He does not. Supreme Court then tells him to do so. John Grisham has written a novel about similar circumstances. When I've told anybody about this, people say, this is crazy. This is really extreme. And what I would say is actually it is a rather logical, the fact pattern, I should say, is a rather logical and predictable result of what's been happening in the last decade, where our organization refers to it as a new politics of judicial elections. Judicial elections, which have been around for a while, have been changing under our feet. And you may or may not be appalled by what's been happening most recently. You don't really have permission to be surprised if you've been watching over the last decade or so. And I'll just add a couple disclaimers. As Mr. Kovner mentioned, we did file an amicus supporting recusal in this particular situation. And I'll add as well that our organization doesn't take any particular point of view on a best or only way to select judges, even though we know that's at the heart of the debate. The setup, I would mention to you, as much as we quite rightly focus on the work of the federal courts, state courts handle 98% of litigation. More than 85% of state judges have to stand for election or retention in their careers. These contests typically have been most often different from other campaigns, but in the last decade it is changing, and more judges are feeling pressure to be more accountable to campaign trail politics as opposed to the law and the Constitution. And I'll just mention 5 trends quickly to get us going here. One is money. Since 1999, Supreme Court candidates in states across the country have collectively raised more than $200 million to fund their campaigns. 15 states have smashed their fundraising records. Illinois, for example, in 2004, the 2 candidates together raised $9.3 million. More than 18 out of 34 U.S. Senate races that year. You had the winning justice on election night say, that's obscene. How can people have faith in the system? The money, the source of the money I can summarize in 2 words, tort wars. This is the business sector, and on the other side, the labor and trial bar sector duking it out in the elections. In terms of TV and the TV ads that are now playing there, this is where I'll show a quick couple minutes of what we have been seeing around the country, and with luck, you will see it on your screen. And I have a volume control.
Never get a fair shake from the Michigan Supreme Court.
Bill, where are my judges?
Just where they've always been, right in your pocket.
Just follow the money. Justices Martin, Taylor, and Young have been given hundreds of thousands by insurance companies in big business. They have the money, but you have the voice. Justice should not be for sale.
Personal injury lawyers. Justice President ruled in favor of trial lawyers who had contributed to her campaign nearly 70% of the time. After a union leader and big contributor complained about a ruling Resnick made, Resnick became the only justice to reverse herself in the case. Alice Resnick is justice for sale.
Children in the house. Once inside, the three children were sexually molested. A 40-year-old girl raped. Her brothers sodomized. A Belleville man was arrested and convicted of the crime after trying to develop pictures of the abuse. Despite prosecutors' objections, Judge Lloyd Carmichael gave him probation, saying the court should grant leniency. Another case where Carmichael let a violent criminal out into the community. Lloyd Carmichael, the wrong choice for Supreme Court.
Tired of lost jobs, skyrocketing car insurance bills, doctors leaving the state, tired of rich, greedy lawyers, irrational judges, self-serving lifetime politicians, tired of our kids being victimized by criminals going free, and you're tired of Judge Warren McGraw, radical McGraw, too many lives, too expensive, too dangerous. West Virginia deserves better.
Unbelievable. Shadowy special interests supporting Louis Butler are attacking Judge Michael Gableman. It's not true. Judge, District Attorney Michael Gableman has committed his life to locking up criminals to keep families safe, putting child molesters behind bars for over 100 years. Louis Butler worked with criminals on the street, like Reuben Lee Mitchell, who raped an 11-year-old girl with learning disabilities. Butler found a loophole. Mitchell went on to molest another child. Can Wisconsin families feel safe with Louis Butler on the Supreme Court?
One story is a fairy tale, the other is a nightmare. The fairy tale, Sleeping Beauty. The nightmare, the sleeping judge, Cliff Taylor.
Judge Taylor fell asleep several times in the middle of our argument. How could he judge based on the facts when he was asleep?
Taylor was voted the worst judge on the state Supreme Court. And fellow judges called for an investigation of Taylor for misconduct and abuse of power. The sleeping judge, Cliff Taylor, he needs a wake-up call.
So ads like that have gone from being the exception just 10 years ago to now the new normal. And if you want to be a serious candidate in a state, you have to raise that money to get into the media markets, and you therefore are going to the groups who then appear before you in court. The other trends I'll just touch on are questionnaires. We are seeing an increase in questionnaires from interest groups on hot-button issues like abortion, same-sex marriage. And the goal is to increase pressure on judges, to essentially check a box in advance and before they even hear an argument in a particular case. Voter turnout, as a general matter, in judicial elections is quite low, and this is because a lot of even good voters will get to the judges and they'll stop. They feel like they don't have enough information. They'll actually say they're being good voters by not voting in a race they don't necessarily follow. The effect of that is to make these low turnout races something of a vacuum for interest groups to try to be attracted to come in. If you can turn out your base, you might be able to tip that election. One other effect is to make them especially susceptible to partisan wins. So you saw in Texas in the last two cycles, in Harris County in 2008 and in Dallas County in 2006, In each case, about 24 judges per jurisdiction swept off the ballot at the district court level. These were experienced judges. The only reason they happened to lose was that they happened to have the Republican label by their name. These were Democratic years in those districts, so their careers are over. They are off the bench. Finally, in terms of public opinion, I would just note that when it comes to these campaign contributions, it's pretty clear. Usually about 3 in 4 Americans will tell you they believe that campaign cash is affecting decisions in the courtroom. Something like 79% of business leaders agree. I would mention as well that another amicus brief signed on our side of the case included signatories from general counsels of outfits like Walmart, Pepsi, Intel, Lockheed Martin. Almost half of state judges in another poll agree with that statement, that campaign cash is affecting courtroom decisions to some extent. And I would note as well a poll we commissioned this winter. We asked people about this issue of recusal. Should judges have to recuse in situations where their major supporters are before them in court? It was pretty much a no-brainer. 85% of Americans agreed with that statement. And I'll just close by saying it was former California Supreme Court Justice Otto Kaus who said about these topics, you cannot forget the fact that you have a crocodile in your bathtub. You keep wondering whether you're letting yourself be influenced, and you do not know. And I guess I would sort of get things going today with my part of this by saying that on June 11th, a couple Mondays ago, 5 of the justices in the U.S. Supreme Court acknowledged the crocodile. And now it's really going to be up to the states to decide what to do with the crocodile. Thank you.
Thanks, Bert. Let's go down to the far end of the table to start, and we'll move this way. And since both Judges C. and Butler have been elected and are sort of personally familiar with the elective process, Judge C.
Okay, thank you. Excuse me. First, let me say it is an honor to be here. I believe in debate. I believe that we learn from one another, and I'm grateful for this opportunity to appear here before you. I looked at the topic, which is judicial elections, financing, recusal, and judicial independence, and it's, I suppose, really a rather narrow topic as how does financing of judicial elections affect judicial independence, and what effect can and should recusal play. But it is necessary to do some background, as Bert did, and I'd suggest that what we need to do is think very seriously about this topic. First of all, there's no perfect system. This is obvious with only a few moments of reflection. We complain that elections are ugly and expensive. Of course, first of all, that's only in relatively few of them. I mean, every 6 years we have over 250 judges elected in the state of Alabama, and I suspect you can't name that many hotly contested, nasty elections. But it is still occurring, and so that is a concern. It is a downside of judicial elections. On the other hand, the federal model doesn't give us a whole lot of reassurance, does it? Now, I read that something in the neighborhood of $14 million has been spent on television ads in the Alito and Roberts confirmations. That's just on television. Surely a whole lot more money than that got spent, and lots of things got said. And those were two relatively uncontroversial nominations. We have another one right before us with future Justice, I predict future Justice Sotomayor, where we're already seeing all sorts of things getting out there in an election that's a lock, or a confirmation that it would appear for all purposes to be a lock. But I urge you, just wait for the next one and see what the tone of that one is going to be. So we don't solve this problem in that way. And the reason ought to be no surprise. It should be no surprise because judges matter. And they matter just the same whether they're appointed or whether they are elected. It's just that the audience changes. If it's the president who nominates, then that's where the emphasis goes. If it's the governor who nominates, then that's where the money goes. That's where the bad mouthing of the potential candidates goes. If instead of the governor it's the public, then the word goes out to the public. If it's some commission, it's going to go to a commission. And let's face it, we're here in Washington, D.C., do we honestly believe that there's no such thing as agency capture, that if we can just have a group decided of prominent people, then everything will be fine. No one will any longer be concerned about their interests, their policy concerns, or their financial interests, and ignore ignore who is going to be appointed or elected as a judge. But then I guess my next question, after cautioning you to think about these things, say, well, what does judicial selection have to do with judicial independence? And let me just give you a couple of things to think about. First, I think we ought to ask, what do we mean by judicial independence? Montesquieu and the drafters of the Constitution, following Montesquieu's suggestion, were concerned about separating powers, not having power concentrated in a single set of hands. They were concerned about other branches' incursions into the judiciary, or vice versa. And their concern was primarily for the sword and the purse, and their incursions into judicial hands. One thing that happens with judicial elections is that the judiciary then has an independent base of support when it is dealing with the actions of the legislature or the actions of the executive. I also, let me point out, the judicial, a second source of legitimacy, of independence for the judicial branch, is the attitude of the public toward the court's legitimacy. And in a national survey of state governments by the National Center for State Courts, concluded from their survey data that ironically, this is the one word I disagree with, ironically, when judges have to run for elective office, people are more likely to think their decisions are above politics. That doesn't strike me as ironic. It strikes me as reasonable. They were involved in electing those judges. They picked judges that they thought would be fair and honest and above politics, and so it would only stand to reason that they would have more faith in their being above politics. Incidentally, a 2002 American Bar Association survey produced the same result, so it doesn't appear to be a fluke. But my point is just these are things to think about. That leads us then to our next point, and that is, well, are voters capable of choosing judges? It's often argued that voters will vote for the one who acts like a legislator and that they don't understand the role of a judge. Well, first of all, that's not what I've seen. I've gone out and I've campaigned, and voters appear to me to be quite well informed as to the relative role of judges as opposed to others. But if it is in fact true that voters can't tell the difference, and they just vote for the one who promises them the most. They don't know and it seems to me they also can't tell the difference between a legislator, a governor, a school superintendent, a state treasurer. And if that's the case, if voters are really too ignorant or uninformed to make those sorts of decisions about who is the best person for which job, we've got a much bigger problem than our judiciary. Our whole system has failed. I don't think that's true. I think our voters do understand and do make decisions based on who they consider most suitable for the job. And I'd suggest to you that social science literature supports that. Glick and Emmert, doing a survey of all of the prior research in the area, in an article, Selection Systems and Judicial Characteristics, which appeared in Volume 70 of Judicature, they conclude, we believe the data employed here is substantial and realistically raises concerns about the openness of merit selection. That's where there's some commission that narrows down the list. About the openness of merit selection in comparison with other recruitment methods. Since the credentials of merit selection judges are not superior to, nor substantially different from those of other judges, the claims for merit selection and the need for bar leaders to have special influence in order to guarantee the selection of superior judges are questionable. And let me also suggest, if there is some problem with the public not knowing what characteristics they ought to be looking for in judges, isn't the answer education, not disenfranchisement? Well, finally, should the public be involved in selecting judges? Judges matter, and they matter on policy. Shouldn't the voters, the owners of the Constitution, have a say in how their judges approach that document? You and I may want people who think like us, lawyers or at least community leaders like us, to make the choices as to how the Constitution will be approached. But there are a lot of people out there who aren't as comfortable with lawyers as we are. I have a cartoon here from Frank and Ernest. They're standing there looking at the Statue of Justice, and one of them says to the other, "I'd feel a lot better about justice being blind if the guide dogs weren't all lawyers." And it seems to me, as the citizens of the state, they ought to have some say, as the public ought to have some say as to this, the choice of judges. If we have already chosen the judges, through people like us, if we've already chosen the judges, it's too late for those judges to decide how to approach the law and the Constitution. That decision's been made. We chose them on that basis. I'd ask, should empathy be a consideration? Shouldn't the people have a say, either through their votes for president and senator, or through their votes for a candidate who does or does not display that background and those characteristics? Finally, does recusal have a role to play? Well, the answer there is, of course, like when Alfred Hitchcock was asked about the background music in a certain movie, and a person in the audience said, was there a reason that was in there? And he said, of course. Yeah, of course. Recusal has a role to play. So does a judge's duty to decide. That's easier and more comfortable to recuse than it is to sit, especially in a very contentious or high-profile case. But parties do not have a right to the judge of their choosing. That we call arbitration. They can choose arbitration if they wish. But ours is a system of justice, not simply one of dispute resolution. Thus, there must be a proper balance between recusal and duty to decide. As Justice Kennedy points out in his main opinion in Caperton, the states can set such rules. Of course, where there are judicial elections, it costs money to get information out. Therefore, he is correct, practically, that the due process clause should be, he says, will be, confined to rare instances. And I guess there are a lot of other questions to be raised by Caperton, and most of those, or not most of those, many of those, you'll find in the Chief Justice's dissent. As the point is, there are a lot of questions that are not yet answered. There are suggestions that, let me say, we're dealing with due process. There are a lot of questions that are not answered. I think we will find that a lot of what's going to happen is going to depend upon how some of those first cases are decided. Justice Kennedy concludes, we find that Blankenship's significant and disproportionate influence, significant, disproportionate, it's an objective test, but it's a very uncertain test, coupled with the temporal relationship, and of course we don't know what that is, between the election and the pending case, offer a possible temptation to the average judge. So this seems to be the standard. Does it offer a possible temptation to an average judge? Well, possible temptation is that would cover just about everything, wouldn't it? But it is to an average judge, so that's going to depend on what judges think average judges are like, to lead him not to hold the balance nice, clear, and true. And then Justice Kennedy says, on these extreme facts, the probability of actual bias rises to an unconstitutional level. There are a whole lot of questions about what those facts are, but I think there needs to be some reasonable balance. I think there needs to be some certainty. Now that we have it in the due process area, the suggestion that there will be very few cases raised strikes me as peculiar. I was sitting on the bench. I saw due process raised in, I don't know, probably a majority of cases. Thank you.
Thank you, Judge C. Judge Wynn, you also were able to steer the shoals of the elective process for judicial office. Could you give us your initial views?
Thank you, and thank you for allowing me to be a part of your program here today. It's a pleasure to serve with such a distinguished panel. Good to be with Justice Harold C. again. The last time we were together, we were in Milwaukee, and they styled it a debate, and I told him, as I'm telling you now, I'm not debating this issue. And the reason I'm not debating is because we agree on more things than we disagree. We agree that judges ought to be fair and impartial. I think we agree that huge amounts of money in any judicial campaign is probably not good in terms of the public's perception on the confidence and trust in the judiciary. And I think we agree that there are ways in which we can improve the system, because we do agree that there is no perfect system, but it does not mean we ought not to work for improvements within the process. I have some experience in judicial elections. I've been in 6 statewide elections in North Carolina, in both partisan and nonpartisan. We currently have a system that allows for public financing of all of our appellate judges. And I'm happy to say that of the 14 candidates that were on the ballot last time, 13 of them participated. It is an interesting system. It is one that works. I know how you raise money as an elected judge. I know exactly how judges, you don't go out and just raise $1 million from the ordinary citizen out on the street. They don't reach in their front pockets and hand you $10,000 or $1,000. They just don't do it. It comes from those who have an interest in the system. We know this. Justice C knows this. It comes from lawyers. It comes from business people who have an interest in influencing the system. And to some extent, that's probably not good, at least in terms of the perception of the judiciary. I'm not talking about actual bias. I'm not talking about whether money actually makes judges rule differently, because I believe deep down most judges don't do it either way based upon money, but the perception is there. The public, for the most part, believes that money influences judicial elections. And for that reason, I think it is an improvement when we implement public financing systems such as the one we have in North Carolina. I also think it's an improvement to elect judges on a nonpartisan basis. This is an interesting process by which we're in terms of how we select our judges. And I typically do agree that there is politics involved both in elective systems and in an appointment system. I know this personally. I was nominated twice for the 4th Circuit U.S. Court of Appeals and never got a hearing to the U.S. Senate. It had nothing to do with me whatsoever. In fact, nothing negative ever came out of me in that whole process. I know it was all about politics. There's nothing I could do about that. I accept that. I accept that politics is involved in the selection of judges on every level. The question is, should we work to lessen the influence of politics in the selection of judges? Should we work to lessen the influence of money in the selection of judges? Should we do these things to enhance the public's confidence and trust in the judiciary, which perhaps is a good thing in my opinion?
Thank you, Judge Wynn. Justice Corliss.
Well, unlike Bert and his organization at Justice at Stake, the institute with which I'm affiliated at the University of Denver takes a very definitive position on this issue and supports what we have come to call a merit appointment informed vote election system, which differs slightly from the Missouri plan and tracks, this will come as no surprise to you, the Colorado plan. This is a position that we take based to no insignificant extent on our experience in Colorado. And that goes to the specific and the generic. I'll start with the specific. I, like the two previous speakers, am a product of that system. I was appointed as a trial court judge and then retained in a retention election. I was then appointed as a member of the Supreme Court and retained in a retention election. My other window into these processes is that as a member of the Colorado Supreme Court, I sat as ex officio chair of nominating commissions around the state during my 11 years on the court. I figure probably more than 20 nominating commissions. So I've seen the way that in Colorado these groups work from the inside. So let me explain to you briefly the way the Colorado system works Then I want to turn to some impressions of Colorado judges about that system, and I'll conclude with why we think it's the right answer. The nominating commissions in Colorado, as a matter of constitutional dictate, are comprised of a majority of lay people. They are appointed by the governor, the attorney general, and the chief justice. They are appointed for terms, and when they were first set up, those terms were designed to be staggered, so you never have a circumstance in which there is a majority of members of the nominating commission who need to be replaced unless there's some mass exodus, and to the best of my knowledge, that has not happened. So the nominating commissions themselves, unlike some complaints that have been made about the Missouri system, are not up for grabs. They can't be appropriated by any particular interest group, including, by the way, the bar, because of the presence of the lay people. And those lay appointees are all the way from teachers, business people, construction workers, people in the community who are interested in their judiciary. So individuals apply for an appointment to the nominating commissions. Once a vacancy is advertised, the nominating commissions sort and cull and interview. Ultimately, they make recommendations to the governor of 3 names, and then the governor has a short window of time in which to make a decision. If the governor fails to act, which has only happened once in my history in Colorado, then the chief justice acts in the governor's stead. The gubernatorial appointment, and by the way, the governors, like the nominating commissions, in my experience, take this process extremely seriously, whether it's for a county court judgeship or a Colorado Supreme Court judgeship, and do a great deal of outreach and background checking. Once the appointment is made, the individual has what we call a provisional term until somewhere around 3 years, but the next general election +1 in some instances, but it is a 3-year provisional term. And here's the piece of the Colorado system which we think is so incredibly important. Between the time that the individual's name goes on the ballot for general public vote and the time of the provisional appointment, we have judicial performance evaluation, and it is a robust process by which lots of individuals who have appeared before that judge are surveyed, not just lawyers, by the way, jurors, litigants, court staff, law clerks, people familiar with that judge's performance. That survey data is collated, digested by a performance commission, which, by the way, is similarly appointed, and then provided to the public so they can make an informed vote about the judge. The performance evaluation data is all focused on process, not outcome. Does this judge provide a fair courtroom in which he or she is respectful of litigants and attorneys? Is he or she prepared, knowledgeable about the law, timely in issuing rulings? Are his or her rulings understandable and enforceable? It really focuses on what it means to be a judge and not the political ramifications of a particular opinion. So the voters have all of that information in front of them for purposes of a retention election. They vote with that information, hopefully casting an informed vote. And at that point, if the person is retained, they stand for a regular term. Depends on the judgeship which he or she holds as to the length of term. So what I would suggest to you is that the Colorado system has a unique way of balancing the tension between accountability and independence, between access by voters to the right to choose their judges, unlike the federal judiciary, and preserving impartiality and the appearance of impartiality of the judiciary. I would note in closing my initial remarks that Justice C is right. There is no perfect system, and the hole that we are working to fill in Colorado is making sure that the voters know about the judicial performance evaluation information, know where to get it, know what it means, and trust the process by which it is collected. The last point I would make is that we did a survey of Colorado judges to find out how they feel about this system and specifically about judicial performance evaluation. And I'm here to tell you that over 85% of the judges in Colorado say that judicial performance evaluation and our system of selection has been either significantly or somewhat beneficial to their professional development and instrumental in their decision to choose the bench as a career. So it's my view that this is the answer to Caperton. We don't need to muck with the questions about how much money is too much. Rather, in our view, any money is too much. Any overt influence of partisan politics is inappropriate in the matter of choosing judges.
Thank you, Justice Corliss. Judge Tiger.
Thank you. I want to start by thanking ACS for having me on the panel. I first met Burt Brandenburg when I was on the ABA Task Force for the Judiciary. I'm familiar with him. I'm familiar with the other panelists by reputation. I'm glad the ACS is looking at the issue of judicial independence. I want to stray for just a moment from the topic of the panel because a couple of people have come up to me since this morning's panel to say that they didn't realize that California state court judges were so well paid. I don't know if you saw that reference, and what I want to say is the difference between what we make and federal judges make is negligible, and after we get done with the voluntary pay cuts that we're going to take in this environment, you can put voluntary in quotation marks, there won't be any difference. So I just wanted to clear that up. I thought I could talk a little bit about what California's experience has been with judicial elections. We have a hybrid system that's like Colorado's in some ways, different in other ways. Not all of you may know what the Missouri plan is that Justice Corliss referred to a minute ago. Although it exists in Missouri, the name has grown to describe any system in which a panel of judges is selected on a merit basis, or a slate of 3 on a merit basis, chosen by the governor, and then that judge stands for retention-only election. In other words, there's no contested election anywhere in the process, and the selection is based on merit. In California, we have retention elections. We have governor appointment in the appellate courts, Intermediate Court of Appeal, and the Supreme Court, and then retention-only elections, and those are 12-year terms. The appointment process is a little more overtly political than the one that Justice Corliss described. The governor has a so-called secret committee in Southern California and a different one in Northern California. Every governor that I know of has had one going back for a long time. I think they ought to just give the committee a name, because secret committee sounds so, I don't know, clandestine, or, it makes you kind of worried when you hear it called that. But it's a committee of lawyers from different areas of practice within the relevant community, just to gather good reputational information about the candidates. Obviously, those are committee members who have some political affinity with the governor, or they wouldn't have been chosen. But overall, I think the committees do a pretty good job. At the trial court level, people apply. Well, let me back up. After they clear the secret committee, candidates are forwarded to what's called the Jenny Commission. That is a California Bar Commission. It's explicitly nonpartisan. It's much more public in its processes. They do a very good vetting process that looks a lot like Colorado's merits review once a judge has been elected. So they talk to judges that lawyer has appeared in front of. They talk to that lawyer's opponents in practice. be careful who you tick off in a discovery dispute. They talk to that applicant's coworkers, and so all this information ultimately makes its way to the Jenny Commission, and they vote a nominee qualified, well qualified, not qualified, et cetera. And the governor makes an appointment decision. In the trial courts, the selection process is very similar with a couple of exceptions. First, we do have contested elections in some instances. It depends on when the vacancy becomes available. If a judge retires or resigns during that judge's 6-year term, because it's 6 years in the trial court, the governor's going to fill that vacancy. Some judges don't agree with the governor's appointment philosophy, and so they will choose to retire or resign right at the end of their term, and if they do that, it goes open for contested election. But also, any of us who've been appointed by the governor have to stand for contested election at the next regularly occurring election after our appointment and for every 6 years thereafter. So if somebody wants to challenge us in a contested election, just like they have contested elections in other states, they can do it. They're nonpartisan, but they are contested. Now, I just want to review with you quickly what California's historical experience has been, and then you can decide whether you think the contested election aspect is a good one. Because I have to tell you, getting ready for this panel, I thought, well, it's pretty close to the Missouri plan. The contested election element doesn't really have much of an impact in California. And in fact, most of the judges I know who are trial court judges are not worried about ever having to be challenged in a contested election. My friend in Los Angeles, who's also a judge, said, I think I'd have to give O.J. Simpson custody of his kids. And if I didn't do that, probably no one is ever going to file against me. And that is true for most of the judges in our state. You really have to be on the radar screen where you're safe. Now, I should also tell you, I think California is a pretty good laboratory. We have the largest judiciary in the world in California. Just our state does. We have about a little less than 2,000 trial court judges. So there are 1,972 people doing what I do. In case you think that we're just relaxing all the time because we have so many people, I have about 580 cases myself, civil cases that I work on. So we have lots to do. But when you add the 7 justices in the Supreme Court and the 105 justices of the Court of Appeal, we have over 2,000 judges in the state. So we have a big data set to deal with. Nonetheless, even though we have so many judges, elections happen rarely. But let's look at what happens when they do. I think we ought to start by saying, why aren't there more? And Judge C touched on this a little bit, and some of the other panelists did too. Economists have describe something called rational ignorance. This is why all of us in the room, for example, don't know a lot more about what Congress was doing last week. In fact, I couldn't name one thing that my senator did last week, and I would challenge most of you to name one thing that your senator did last week, and that is the benefit to you of knowing that information is pretty small. And the cost to you, in time at least, of getting that information is pretty large. Well, the same thing is true with trial court judges in California. We have very big counties. It would cost a lot of money to conduct a judicial election, and people, for the most part, feel kind of disconnected to the judicial process. Another, I think, point of agreement I would have with Judge C is we probably need a lot more civics information, civics education in the United States. You see the West Virginia ad that Bert showed where they say, are you concerned about lost jobs? Are you concerned about car insurance rates? And I would suggest to you that if your first impulse is, yes, and so I'm going to elect a new judge, then probably you need to know a little bit more about how things work, because that's probably not going to do it for you. And so anyway, this kind of rational ignorance and the amount of money that it takes to mount a judicial campaign explain why there aren't very many elections. So in this balance between accountability and independence, you think, well then, maybe judges get unseated when a judge is doing a really bad job, right? I mean, that's what it is. The voters would say, finally, this judge is just doing so terrible of a job, that's why we'll unseat a judge. The last contested election that I'm personally aware of, although it comes from news reports, is in 2006. A judge named Dzintra Janovs was challenged in a contested election, and she was unseated. She'd been a judge for 20 years. Her work ethic and her intellect were beyond question. Her name was unusual. She was born in Latvia. She had a strong accent. But as I said, her ability to do her work as a judge was, I think, beyond dispute. Her challenger was the owner of a bagel shop in a community called Manhattan Beach, whose bar license had been on active status for only 6 of the 16 years that she'd been admitted to practice. In California, you can be a member of the bar and be what's called inactive. The supposition on the part of the media was that Judge Giannos was susceptible because of her unusual last name. And when the media went to her challenger, she didn't deny it. And her challenger, whom I'm not going to name because this is someone who's now one of my colleagues, won that election. And I have to say, in Governor Schwarzenegger's favor, he subsequently reappointed Judge Giannos to a different vacancy, and so Judge Giannos is also, again, one of my colleagues. Another recent example, although this is not in a contested election context, it's in a recall situation, is Judge Lauren McMaster in Sacramento. Many of you are probably familiar with the gay marriage cases in California. This is before all that, when California's legislature enacted a domestic partnership regimen. And in 2004, somebody challenged the regimen on a variety of grounds. In that case, found its way in front of Judge McMaster, like me, just a county trial court judge in one of California's many trial courts. And he upheld the law that had been passed by the legislature and signed by the governor. So a coalition of conservatives in Sacramento County started a recall campaign against him, and the petition said, this is from the petition itself, McMaster has violated time-honored standards to stay independent from political parties and to not legislate from the bench. He has become a political activist. This is what he got for upholding a law that had been passed by a democratically elected legislature and signed by the governor. We don't have a lot of laws in California that have been blessed by all 3 branches of government, but this was one of them. And fortunately, the Court of Appeal took very quick review and affirmed Judge McMaster unanimously, 3-0, and that was the end of the recall. And we have to wonder what would have happened if the Court of Appeal had delayed a longer period of time. And then the last example I would give you is more than 20 years old, and that was the unseating of the Byrd Court in California. Who here knows anything about Rose Byrd? Raise your hand. One of the things I love about this conference is how young it is, and so I just wanted to do a little barometer check. Anyway, it had never happened before. It has not happened since. A Supreme Court justice lost a retention election. Rose Byrd and 2 of her colleagues were unseated in a recall. Justice Byrd, that court had taken 64 capital cases and had given relief to the defendant in 64 of them. And in 61 of those cases, Justice Byrd was joined by at least 3 of her colleagues. So many of you in the room are saying, well, it can't be the law in California that you can never apply the death penalty. And that's what the ads were about. And I'm not going to agree with that. I'm not going to disagree with it either. I will tell you that the money for the ads came from business groups, which I think begs the question of the efficacy of this process and why it is that the recall actually took place. So getting ready for this panel, as I say, I was a huge supporter of the California system, but by the time I was done getting ready, I think whether elections, even at the limited extent that California uses them, I think that's sort of an open question, and I've been very interested to hear what Judge Corliss had to say today.
Thank you, Judge Tiger. Well, we've now heard 4 thoughtful presentations about how the selection system works in 4 states, and obviously there are just reviews, as we've heard. One thing I think we can agree on is that there will be judicial elections for the future, at least in the near term. So I wanted to start with the current issue of the day that I think the Supreme Court in Caperton has put before us, and namely recusal, that is, some form of mandatory disqualification where certain persons, possibly parties or perhaps lawyers, have made significant contributions to a judge. And Indeed, Judge Kennedy concludes his majority opinion with citing the amicus brief of the Conference of Chief Justices, which advocated that for the proposition that what happened in West Virginia, and you saw one of the ads, was a violation of due process, and then quotes his own concurring opinion in Republican Party of Minnesota versus White, and says, "It is for this reason that states may choose to adopt recusal standards more rigorous than due process requires." And so I think I've heard, as I say, unanimity here that too much money is a problem, presents problems in terms of the appearance of impartiality, in terms of independence. I'd like to throw out to the panel the question of whether, as a matter of their own state laws, where there are states with election, who use the election method, the partisan election method, what recusal rules might be appropriate? How might they work? Because I think the Supreme Court has put that on the doorstep, on the agenda of at least the 39 states that have that rule. And while people, since I didn't give them a signal as to my question, I'll start with Bert. And then anyone else should comment.
Sure. I'll start with one or two thoughts. One, as Justice C. noted about Justice Kennedy's opinion, the opinion sets a floor. There is a point at which the due process element becomes so extreme that the Constitution comes into play, and it's absolutely true that these states are free to, and I think are encouraged to, and have already at times set standards that you could argue are above this due process floor. What I think above all, even above the specific provisions you might argue for that the Caperton case does, is argue for a kind of wake-up moment for states in this regard. Recusal has been a poor stepchild in these debates for a number of years, and it's finally getting some of the attention that I think it's due. When you get to the point where the Supreme Court addresses it, when John Grisham writes a novel about facts that he said were similar to those in West Virginia, then I think a moment's been reached where the states need to take it more seriously than they have. And one of the prime reforms I think that's been offered up that was not discussed in Caperton in terms of the process is the issue of who decides. Should the judge, who is the subject of the motion, automatically always be the person who decides that case? And I don't have the magic words to rewrite that rule automatically, but I would say not always. If we acknowledge that judicial elections are changing, that the amount of money going into it is serious and that judges might need to recuse, we should also acknowledge that maybe they shouldn't always be the deciders about that very issue. There are alternatives. You can go to other judges. You might have other panels. You could even have, if you wanted to be serious about the issue of judge and lawyer dominance, you could have an outside panel that maybe looks at these issues. Maybe it has some judges. Maybe it has some lay people. It gets tougher at the high court level because there are fewer people. But again, there are alternatives if you want to do it. And I think in terms of this issue of public faith in the system, I would put this one pretty high up in terms of consideration. And the other one I'll just note quickly and let others say more about is getting back to the issue of how much money and what kind of money it would take to trigger an actual recusal. Again, we've seen one extreme case. There was not an attempt to define out what the others may be. I think it would be properly up to each state to decide in the case of its own political culture what kind of money makes sense in terms of triggering recusal. But I would note that Justice Kennedy quite explicitly left open the idea that there could be recusal not just for a direct contribution to a candidate, but for independent expenditures on behalf of a candidate. And what that's going to mean if a state wants to take that seriously is in most cases better disclosure laws. These can be very hard numbers to come by sometimes, and if you take this seriously, I would argue that you're working on your recusal reform even as you're working on your disclosure reform.
Well, I don't want to let you quite off on that, Bert. How much is too much? Do you have a view? In other words, what level of contribution should trigger a recusal rule? I'll ask this of the others as well. If you were vested with the authority to adopt rules of judicial conduct in a particular state?
In the state of X, let's call it a fairly average state, I'll just say that our own public opinion poll, and we probed this too, and we asked people, should there be recusal if $50,000 was involved? And we asked a separate set of people? Should it be recusal if there's $1 million involved? We didn't see much difference in people's answer. And I think, at least as a starting point, a number like $50,000 or $100,000 would be a good place to begin a discussion. I don't pretend to have the exact answer in a particular state.
Anybody else wish to address this subject?
I was one of the drafters of the 2007 revised Model Code of Judicial Conduct for the American Bar Association, and I've sat as a chair when we revised Canon 7, which dealt with election of judges on this whole subject matter. And most recently, I wrote an article on this very subject in the Judges' Journal on recusal and disqualification, and it's an ongoing situation. That section that's quoted in Caperton comes from the Model Code of Judicial Conduct. I don't think it is proper or even prudent to try to set a figure. Why get into that debate? That's what courts do. Courts determine, and we determine, those kind of issues where you don't have a bright line answer. The answer within the code is you would recuse when your impartiality might reasonably be questioned. And that's a standard by which we've employed. The ABA Model Code is the one that's mentioned by Kennedy. The whole nub of this thing comes down to the differentiation of what is bias, whether it's actual bias or do you employ the appearance of bias or the appearance of an impropriety. And when you're dealing with the appearance standard, it is a reasonable person standard. So $50,000 may not be, but who knows? If you know the circumstances on which it was employed, did $50,000 make the difference in the election of the judge? And again, I don't think the issue is whether the judge actually was biased. It may not have been the issue even in the Caperton case as to whether Blankenship, whether the Judge Benjamin was actually biased. The question was, did it create the appearance? And I finally say with regard to the Caperton case, I think everyone sitting at this table would agree that there's definitely something wrong with, from a factual perspective, when one a potential party gives $3 million to a justice who becomes the deciding vote in overturning a $50 million verdict against that particular party. There's something wrong with that. But that, of course, was not the issue in Caperton. The issue in Caperton was a constitutional issue. And when we turned upon the constitutional, we got into a whole different argument in terms of policy versus the law. But the ultimate result here would have been, I think, notwithstanding all of the prediction perhaps of Chief Justice Roberts, is I just couldn't imagine that the court would have gone another way on this in terms of the public confidence question.
I actually depart a little bit from Judge Wynn. I agree that the question of who decides is very important. I agree with Byrd. It's not the judge in the case. I think in California, if somebody makes a motion for disqualification, we have a procedure for making sure that's decided by another judge in another county, and that process works very well. But I don't think that's a process we want to use here either. Caperton was too easy of a case. I think we need to start there. It's too easy. It doesn't help the debate to say, can we acknowledge that $3.5 or $3 million is a problem? Of course it is. And I actually think, and I differ from Justice Wynn about whether we ought to set a bright line. I think it would be helpful to do that. And I think who ought to do that, it depends on who's the rule maker in each jurisdiction. In my state of California, the Administrative Office of the Courts and the Judicial Council work hand in hand to create the rules of court, and the ethics rules are written by the Supreme Court, and your states may be different. I think it ought to be in the ethics rules, and I think the bar ought to be fairly low. Because I think what's at stake in each time this comes up is that the threshold for due process is a lot higher than the threshold for public confidence. I'm not surprised that at $50,000 or $1 million you get the same survey results. I bet you'd get the same survey results at $1,000. $1,000. Ask the average person on the street right now, go out to Connecticut Avenue and say, I have a case coming up next week, and I just found out that at the election the other side gave the judge $1,000. Do you think I should be worried about that? And come back in here and let me know what they say. Because I think the data will be pretty good for this point. And so the rules are a chance for us to reinforce the legitimacy of the judiciary. You know, we just have those robes. You know, people bring their disputes to us and they give us this power because they think we're going to do it fairly. And so I get very worried about anything that undermines public confidence in our impartiality. So I'm a believer in bright line rules. I don't think they should be set on a case-by-case basis. I think common law would be a disaster, but I do think we ought to have bright lines.
Anybody? Judge C?
Well, I agree with James on this. I think you can't effectively set a bright line rule. And the reason is, there are a lot of reasons. But first of all, does anything besides money matter? If it does, whether someone should recuse. If it's only money, you only have to recuse if it's money. Okay, we set a bright line rule. But if other factors matter, they have to balance into it somehow or another. And it may be more money and less of them, or less money and more of them. And as James points out, this is the kind of job that courts generally engage in. It also suggests, $1,000 sounds like a lot of money, but if we're going to have elections, and I understand if you say abolish elections, they're evil. Yeah, I think there's evil. I think there's evil in the other systems, and I think there's good in elections. So I urge real contemplation, real thought about it, and real analysis. If you're going to abolish elections, say nobody can give more than $100. Then you can't get word out. And I think it's best for there to be information, for people to vote knowledgeably. And one of the first things I learned when I ran was how cheap it was to run one commercial one time on one small television station. The next thing I learned was how many commercials you had to run how many times on how many stations in order to get anybody to notice you at all. So it costs some money. It costs money to get people organized, to get literature out to people so they can hand it out to their neighbors. These things cost money. If you're going to have elections, then you have to have money involved. Now, what you want to do is not have that money destroy the confidence in the electorate. But as you may have noticed, the only 2 surveys I'm aware of that ask say that the public has more confidence that the judges stay above politics if they have been elected than if they have been appointed. And you ask any group here, what do you think? Do you think that the Supreme Court stayed out of politics in Bush versus Gore? They weren't elected, so obviously no problem. But let's see. I had one more note here. I'll just let it go at that right now.
Becky.
Again, I have to preface my remark with the acknowledgement that I'm taking a purist position. But it is my view that the question of how much money creates an appearance of impartiality is an unseemly question, and that the mere fact that we have to ask it should suggest that we need to revisit this particular system. I think the polls, and Bert really is the expert on this, so I'm inclined to turn to my left, but it is my understanding of the polls that it is absolutely true that the American electorate, when asked, would you be willing to give up your right to vote for judges, particularly if it's posed that way, will say in a fairly loud voice, no. But conversely, if you ask them if they would like to walk into a courtroom where their opponent has given money to the judge, they will in even greater numbers say no. So in my view, the fact that the public views their right to have a vote about the judiciary as sacrosanct does not mean that they prefer contested elections, or particularly elections in which judges have to raise money. So on the recusal issue, my view would be that what Caperton says is money in the courtroom is something that legitimately can create a probability of bias. And now, are we really going to ask how much?
Could I?
Yes, go ahead, Judge C.
This is really the point I was going to make earlier, and it's been brought out here, and that is that the justice is suggesting retention elections. That costs money too, especially if someone challenges. So if that's unseemly, it seems to me you're taking an inconsistent position. There ought not be retention elections. I think retention elections make sense. I mean, I think contested elections make more sense because then you have someone with an interest who brings out information about the person. And as John pointed out, I think that's what voters do. They look for the information. Let me say, there may be a difference between Alabama and California. We have lots of lawyers with accents from other countries who are elected time and again. I'm trying to think. Bayhackles in Birmingham are a whole family of judges. But anyway, yeah, sometimes wrong decisions get made. Sometimes wrong
I didn't mean to
appointments get made.
suggest that the opposite is true in any kind of statewide way in California.
Okay. It kind of sounded that way. But the point is that that information costs money. If there are going to be retention elections, it costs money to get information out, unless you're going to say that only one group has a monopoly on the information and can get the information out.
Let me add one point with regard to the system itself, so that this is my perception. I've been a judge for going on 19 years, and I'll tell you what, most judges would recuse themselves without question on these kind of cases. The Caperton case would never happen in most states. I've never seen anyone do that. And in fact, the opposite is the problem, is judges who just are ready to recuse themselves from a case, even if there is some indication that there's some bias. Someone brings a question, I recuse myself. And he's off. And so the question is, the duty to serve is really being implicated. But I'll take this further. There are serious issues with disqualifications and recusal. I do not think the money is going to be the problem. I think it's issues. It's the question of whether, when issues come before the case, in the Scalia instance, of whether that creates one who's not impartial, as to whether it must be actual bias or whether the appearance of it is significant enough to require recusal.
I want to move on in just a moment from how much. I didn't give sufficient note to the distinction of the North Carolina system, which is election with public financing, which is very different than election without public financing. And before we leave how much, I should say, Judge Tucker, so you're not alone, the Fund for Modern Courts, which favors merit selection over election but doesn't expect it soon, recommends recusal if there's been a contribution by of $1,000 or more by an attorney, an individual attorney, or a party, and that the burden shouldn't fall on the judge but upon the attorney to make that disclosure.
Victor, can I just say one thing? This follows logically, I think, from something that Justice C said a minute ago. He said, if we're going to have elections, where's the money going to come from? And if you set these kind of recusal limits, then people are going to have a hard time getting money. I'm not talking about people that talk about setting a low recusal trigger are not talking about putting caps on contributions. They're talking about having a low recusal trigger. If we think those are the same thing, then we think that nobody is ever going to give money unless they know that they can both give money and have the right to appear in front of the judge whose election they financed. And I just think that's a different point.
Good point. I'd like to go to the issue of diversity. It comes to mind as you tell the story of the judge with the unusual name. I have a friend who, one of our finest judges in New York, a woman named Sheila Abdul Salam, feels it would be very hard for her to run statewide. I'd like the panel to comment on the question, what impact, if any, favorable or unfavorable, on diversity does election versus some kind of merit appointment have in terms of the composition of our judiciary?
Well, I can start.
Please.
People who do the sort of meta-studies and look at a lot of national and long-term studies basically come up to the conclusion, I would say when you aggregate them all, which I would argue against, but the general conclusion is that there's not a huge difference, or as I would put it, they're all bad at promoting diversity historically. I think within that overall number, however, there are some interesting both things to observe and I think perhaps changes that might be underway. In the case of merit selection, the case has always been made against it. It can be a closed room, and in particular for communities of color and for women, that a closed room had always been the worst possible selection system, that there was a feeling for many years that amongst minority judges in particular that an election at least maybe gives us a better shot, particularly in municipal areas where there might be party or other political infrastructure to support you. I would say, anecdotally, I sense some change in that, and others here I think may be more expert on this, but I feel like I've been hearing a little bit more in the way of mixed opinions, perhaps as politics itself is changing a little bit. The other thing I would say that's also changing is if one believed that elections might give you a better shot, there too, that may be changing given the amount of money it may take now to be competitive, and communities that don't feel like they have a leg up in that type of fundraising race in all kinds of political situations are similarly starting to say maybe elections are not better.
So you know of no statistics indicating one way or the other, or studies that have addressed that?
Nothing decisive.
I asked Chris Areola, who's the past president of the California La Raza Lawyers Association, this question a few days ago, actually. And he said he likes judicial elections because he feels as though his community, which is the Hispanic bar in California, can put its candidates on the bench using elections when the governor is not listening to them. And he was adamant about it. And I have no reason to think he's wrong. I think a couple things. It's very community specific. Even within California, there are counties when you get a diversity benefit from elections and counties where you don't. So that elections can wind up producing judges that look like the majority all the time or most of the time in some counties. Not in San Francisco, where different interest groups have been very effective in putting their candidates on the bench. The gay and lesbian community in San Francisco also has been very effective in using judicial elections to make the bench more diverse, and I think they would say the same thing about elections. And I have talked to some people from one of the gay and lesbian bar organizations, and they did say the same thing. I think the other thing to remember about the other two things to remember about diversity are, first, once you identify it as a positive, sometimes in elections, that means if you're going to take elections away, then you have to strengthen merit selection to make sure that they pay attention to diversity. Because there are people in the community who think it does produce that benefit, and it's an important benefit. The other thing to remember is that in elections, not just diversity interest groups, any group, they don't go after the worst judge, whatever you think worst means. They go after the worst candidate. They go after the candidate who they think is going to be the easiest to run against. And sometimes by coincidence that's the worst judge, but the odds are pretty good that that's not who that is. That's not a good thing or a bad thing. It's just the way it is. It just means that it's a mixed blessing, I think, of elections.
My understanding, like Bert's, including Brennan's most recent study, would suggest that there are equal deficiencies in both selection methods in terms of producing a diverse and representative bench. I also would agree that in a system like Colorado's, there not only has to be a commitment to recruiting candidates, and that is a commitment that the minority bars undertake, sometimes fairly successfully and other times less successfully, but there also has to be record keeping. And that's something that we have started only fairly recently, to keep track of the numbers of applicants who are women or who are from the African American or Hispanic communities or the Asian American communities, so that there is an understanding of how those applicants fared in the process, whether they ended up on the ultimate list of nominees to the governor. And then we do have the public record from that point forward as to whether they are appointed and whether they are retained. Parenthetically, just one thing I wanted to clarify, and then one sort of anecdote. I did want to clarify that retention elections in Colorado are not contested. If someone is opposed, it still is a yes-no vote. And the entire judicial performance evaluation process is publicly funded. It's statutorily funded through the general fund. Now, the anecdote, we teamed up with the League of Women Voters in Colorado to do surveys of voters to find out how they vote on judges and whether they are aware of the judicial performance evaluation information. And what we found is that there are an uncomfortable number of voters who do not know where to get information about judges and who therefore either choose not to vote or vote from an uninformed perspective. What we noted was that of the uninformed voters who choose to forge ahead, men are more likely to vote no under those circumstances, and women are more likely to vote yes.
Does no mean retain or out? You're out.
No means you're out.
I don't know anything, you're out.
Right. And there are other very amusing sort of wrinkles in the data, some of which relate to who votes on the basis of last name and what they think that last name connotes, whether they think it's a woman or a man, or what they think their ethnicity might be. But they also vote in terms of placement on the ballot, alphabetizing names on the ballot, and are more likely to vote if you're toward the top of the list.
Can I ask
Yes,
the judge
please.
a question? So how are the performance evaluations distributed? How do people become aware of what the results of these evaluations?
They're distributed in a number of ways. They're on the Judicial Performance Evaluation website. They're distributed in what we call a blue book that goes to every voter household that gives information about other candidates. They are in that publication. Newspapers used to publish them and also to couple them with either endorsements or lack of endorsements. That, like most of the rest of the newspaper business, went by the wayside to some extent in the last campaign. There are inserts that go in newspapers in some of the smaller communities that contain all the judicial performance evaluation data. And Arizona, by the way, which has a very similar system, Chief Justice McGregor did radio advertisements in the last election, just very short blips in which she informed the public about the judicial performance evaluation data and urged them to know their judges before they would vote. And I believe the data on that suggested that it was fairly successful.
May I just
Yes,
say,
Judge.
I am all for that. I think I like any evaluation. I want the newspapers to do it. I want the unions to do it. I want the trade associations to do it. I mean, I think more information is good, and I think the bar associations ought to be actively involved in it, and the judges need to get out and talk to people as well.
We're going to go to
Let me
Yes,
give this
Judge.
diversity thing. I feel compelled because I've just spent a year as the chair of the American Bar Association's National Diversity Summit. It started with the mid-year meeting, which we had national hearings, and then we've had 4 regional hearings around the country. And just this past week, I'm coming from a 2-day conference we had over at the Gaylord National Center, in which we brought in experts, we brought in scholars and individuals, spent the entire time talking this very question on diversity in the judiciary, and to the extent that how elections and non-elections or appointed systems may work, one of which was one of the presenters, John Britton, who's worked with Justice of State and some of the other groups, talked about surveys of other judges out there who had been in the process. And they did come out with that conclusion that the difference was not so much the type of selection system. There were other factors that were involved in it. I think that the interesting thing and the crucial thing to think about, and it was enlightening to me just being a part of the process, is the broad definition of diversity. It is much more than racial diversity and gender diversity in terms of what's out there. There's a segment from the disability area. There's the sexual orientation segment, and other segments out there in the population that are being affected. And genuine concerns in terms of how diversity is affected, not only in the judiciary but in the legal profession. I might add that this is an ongoing project, and so if you're interested in it, you can Google the ABA on this diversity summit. We will conclude next step would be at the annual meeting.
We're going to go to audience questions in just a couple of minutes. I've got 2 short questions. One is for Judge C., and that is, you made a forceful case for the election system as you perceived it in Alabama, and expressed reservations about what is sometimes called a merits election because an appointing authority has perhaps undue discretion and influence. If there were a system in which the commission, which recommended people to the appointing authority, were bipartisan, broadly based, in which the governor didn't control it but had only a voice on it, would that ease some of your concerns that you expressed about merits election?
But it sort of gives the baby away with the bathwater, doesn't it? I mean, if it really represents everybody, yeah. How can you do that? Well, you could have an election.
That's a fitting, forceful answer. I have one other special pleading question for Justice Corliss. Twice you referred to people giving up their right to choose judges. Isn't it true that when the nation was formed, we didn't elect judges, and we didn't elect judges for about 60 or 70 years, to about the 1850s, when many states chose to go to an election system. And so what we voters have is a right to adopt an election system or a appointive system of some sort, not a constitutional right to vote for judges.
Absolutely. And I think that although the Supreme Court opinions on this point, Lopez-Torres most specifically, have recognized that each state may do as it wishes, I think there is also a recognition that there is certainly no constitutional right to vote for judges. And that then leaves the question open for each of the states to re-examine procedures and try to adopt the one that they genuinely believe is most likely to produce an impartial judiciary.
Okay. I'm now reminded that it is time for questions from the audience. Do we have mics? Oh, we do. Let's start with this gentleman here. Then we'll go to the back of the room.
I was wondering, sort of a follow-up to the last question, do states change their judicial systems very often, or is it that a state has its system that it tends to keep? And if they do change, are there any trends?
Lately, not very often. The trend was being described a minute ago was the colonies mostly came out with systems similar to the federal government. The Jacksonian populist era gave us judicial elections. Most states after that, pretty much every state adopted them in a competitive form in some fashion. Merit selection came along in the early 20th century in some ways in reaction to some of the trends in judicial elections. And over about a 30, 40-year span, a number of jurisdictions moved to that system. Since that period, since about roughly the 70s, I think, there's been very little change. It's more kind of, for those who want to change one way or the other, more sort of trench warfare. Legislatures and particularly electorates, because this is typically now a constitutional provision in a state, which therefore will require a ballot measure, have not proved too eager to move one way or the other. The final footnote I would add is that in two cases last year in 2008, counties were asked to consider whether to move for or against merit selection. And in the case of Greene County, Missouri, very conservative county where Springfield is, they actually moved towards merit selection from contested elections. In the case of a county in Kansas, whose name is escaping me, they rejected an effort to move away from merit selection. So score keeping last year shows that in two cases, fairly rural jurisdictions actually liked merit. But overall, the trend of the last 20, 30 years has been not a lot of movement.
Or as someone said earlier, court reform is not for the short-winded. In the back.
Yes, are any of you concerned that if you set a minimum level at which you have to recuse yourself as a judge, if a state does, say of $1,000, then parties might actually use that to force the recusal of judges they don't like? You know, I know in Illinois, for instance, judges on appellate panels can't even be replaced. So if if a party knows that it's going to have an appeal that reaches the Illinois Supreme Court or an intermediate appellate court, and the judge has no way of knowing that that case may be coming up eventually if it's several years before trial even, you contribute $1,000 to the judges you think will rule against you, and then when you finally get to the Court of Appeal, they have to recuse themselves. What might be done to address that problem?
Well, let me say it's a little more complicated than that even, and that is in Caperton, the suggestion is there. It depends on whether you deal with the actual facts of Caperton or the ones that are kind of discussed, but under the actual facts of Caperton and under the suggestion of the language of Justice Kennedy, even if the judicial candidate turns it down, says, I will take no contribution over $999, they could go to someone who was against your opponent, contribute the $1,000 there, and arguably you'd have to recuse. Now, I suppose that's if that sort of due process language carries over into state recusal rules. State recusal rules could say no, I mean, that it's only a direct contribution. But if that's the case, then, then you have to decide whether you're doing the job you want to do.
Well, first of all, I think my earlier comments were not just, I used $1,000 as an example. I don't have a view as to what the limit should be. I don't think it should be decided on a pop quiz basis by I think we're all pretty smart, but I don't think we're the ones to do it for all 50 states. I think the states have to make those decisions. My comments were more directed at who makes that decision. I think it's important to remember, first of all, your question is an excellent one. That's a real problem. Triggering recusal happens not just with respect to campaign donations, but otherwise, and it's a legitimate concern. The concern is going to arise no matter what happens, because in the future, this issue will be decided somehow, some way, when it comes up again. The only thing we know right now is you can't give $3 million. But the case is going to come up again, and then someone's going to set a different limit. And so I think it's a legitimate concern. I think it's probably unavoidable.
Well, and I would just add one other thing. It's a very good question, the issue of just gaming the system by writing one check. And the people who've been promoting recusal reform have strongly, for that very reason, proposed the idea of a simple waiver on the other side, where if the other counsel thinks the gaming is going on, you say, okay, we don't need it in this case. So then that hopefully will then deter the issue of the kind of phantom checks being written.
And keep in mind also the code has other provisions in it. One, the duty of the judge to serve. If a state made a law that said that $1,000 would lead to your recusal, the question would be is whether the judge can accept that $1,000 knowing he cannot sit on any cases dealing with that particular entity.
And the other point that your question raises, which is near and dear to my heart, is the particular posture of an appellate bench as to which no substitution is available. Colorado has a 7-person Supreme Court. If one person has to recuse in a particular case and there's a 3-3 split, it's an affirmance by operation of law, and the court is not exercising its constitutional responsibility to decide the case. You can't just bring in another judge.
It's difficult to draw a recusal rule. A lot of thought has gone into it. It has to be done on a state-by-state basis. But a lot of problems can be avoided. Next question down front here, this gentleman. We have time for just a couple more.
I think it was Judge Tiger said before that Caperton was an easy case. And, of course, about 40 or 50 years ago, there was another easy case in front of the Supreme Court. That was the easy case of Baker v. Carr.
I recognize that 4 justices of the Supreme Court disagree with me, by the way.
Well, and my question is, of course, Justice Frankfurter disagreed with the resolution of Baker v. Carr and wrote an opinion very similar to Chief Justice Roberts' opinion, where he made the argument that this creates a whole mess of uncertainty, and we don't know what to do with it. All we know is that we don't know, and how are we going to have elections when no one knows what the rules are going to be? And as it turns out, the inferior federal courts and the state courts are pretty good think tanks when they have to deal with the problem, and they figured out a pretty good solution. So, for Justice C or anyone else on the panel who's more sympathetic to Chief Justice Roberts' view, how do you address the Baker problem?
Let's start at the beginning here, and that is I was on a panel before the decision came down where someone made the point that in general the advocates for Caperton were making, which is, look, this is a clear case. It's not really going to change anything much, but this case ought to be decided this way. And it hasn't taken long after the decision came out to see, let me back up. There was a very good plaintiff's trial lawyer on the panel who, frankly, was on Caperton's side, but he said, obviously, I'll use it. And he said, and the guys on the other side will use it too. Right? I'll use it for to get judges sympathetic to my case. They'll use it to delay. Some defendant doesn't want to pay, so he files a recusal motion, and so we're likely to see, and there's some lawyers in this recent ABA article who are making the same point. We're likely to see a whole new stage of litigation. And I guess what I'm reminded of, when I first went into practice, the old-time lawyers told me about how discovery was supposed to make everything quicker and easier and cheaper. And, in fact, it's turned out the other way. You've got a whole new, now you have lawyers who become partners never having tried a case. They've just been in discovery, all that time. I think we could well see that. There's a caution here, though. And that is you have to remember who's going to be deciding these motions. And the standard sounds very broad when you say we find that Blankenship's significant disproportionate influence offer a possible temptation. Well, that would be anything, right? I mean, yeah, and so you'll always have recusal. Of course, the system wouldn't work that way, and the judges know that the system won't work that way. You can't let each side get rid of half the judges, right? And so there's some more language here. It says, offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. And so these judges are going to be deciding, well, what would be a possible temptation to the average judge? If we preserve, and he doesn't say whether we do or not, but if we preserve the presumption in favor of a judge being non-biased, and if the courts are strict and really do say, no, it's going to take extreme facts, then it seems to me we control that rush. I mentioned all these due process claims, but most of them we wash out pretty quickly. They're obviously without merit, and so judges can do that as well. And we could find this actually not making a lot of changes. The question then would be, well, what changes will the states make? I mean, this is something else you see a lot of people saying. What an opportunity to go try to get the state to do something more. We can point to this decision, and I think that's going to happen. And as they point to it, then I think there's going to be a review of recusal standards within the states. And I don't know what's going to happen. Now, California, I think, allows a first strike, right? You can get rid of one judge.
Yeah, we have what's called a peremptory challenge.
Yeah.
No,
so,
you don't need to give a reason. You can just say, I don't want that judge.
Yeah, but that's just good for one. You can't do that on infinitum.
Each side only gets one.
And then that allows the system to continue to operate. Now, in Alabama, we don't have so many judges. In fact, we in some places there may be 2 or 3 counties with a single judge. Well, then when if there's this lax attitude toward recusal, which, as I've mentioned, it's a lot easier to recuse than it is to hear the case, and so it's a temptation of the judge, there's more justification for him to do it, then the Chief Justice has to appoint a replacement judge from someplace else in the state to drive over there to handle that one case. Our Chief Justice already spends an enormous amount of time making special appointments in order to handle situations under the old rules for recusal. And it could become quite burdensome.
I've been given the now clear signal that unfortunately our time is up. Please join me in thanking our panel.